We've all seen the images depicting life under Jim Crow, and the separate wasn't exactly equal. We've seen the pictures of the water fountains for whites and the water fountains for blacks, and these pictures are now iconic and shocking. But images alone is not enough to prove that the separate but equal doctrine was a violation of the constitutional right to equal protection. There had to be more. And this is where Thurgood Marshall and the NAACP Legal Defense Fund and Brown versus Board of Education comes in. Thurgood Marshall and the NAACP Legal Defense Fund had argued that keeping black students separate from white students violated the equal protection and due process clauses of the 14th Amendment. In 1954, the Supreme Court handed down the Brown versus Board of Education decision that ruled that segregated schools violated the Equal Protection Clause of the 14th Amendment. This ruling desegregated public schools, and it did something else. It allowed the Supreme Court to define the Equal Protection Clause. It did not, however, examine whether it also violated due process clause. That's something that could prove problematic later on. Rather still, the Brown decision became the precedent that made America more free and more inclusive. Couples won the right to use contraception. State laws that had banned interracial marriages, like my marriage, were ruled unconstitutional. And marriage equality for same-sex couples was decided under the same right to privacy and the Equal Protection Clause. Sidebar. In 2019, former President Donald Trump, with Mitch McConnell as Senate Majority Leader, started pushing the nomination to the federal judgeship men and women who would not affirm that Brown versus Board of Education was rightly decided. This raised a red flag for many people, myself included. Brown versus Board of Education decision hasn't been controversial for decades, at least not openly. You'll be hard-pressed to find anyone vying for public office or judgeship who wouldn't say that Brown wasn't rightly decided. So this was alarming. The Plessy versus Ferguson allowed states to maintain separate facilities for black and white citizens. This included public schools. The students that attended these schools and their parents knew these schools were not equal. The black schools were often given old textbooks thrown out by white schools. The tax dollars that were collected for all students were spent updating white schools while the schools for blacks and Negroes were run down. Some Negroes were allowed to apply for white schools. You know, that whole school choice thing. This is where that came from. Thurgood Marshall was chief counsel for the NAACP Legal Defense Fund. He and the LDF sought a case that would challenge the court's Plessy versus Ferguson decision. In 1951, a father named Oliver Brown brought him such a case when Mr. Brown's daughter Linda was denied entrance to an all-white school in Kansas. Marshall agreed to take the Brown case, and it went all the way to the Supreme Court. Brown versus Board of Education wasn't just one case. It was 5 separate cases. These 5 cases sought to challenge the separate but equal doctrine. All 5 of these cases became known as Brown versus Board of Education. Now, when you think about the history of this country, we think, of course, the North was going to beat the South. Of course, the Supreme Court would rule in favor of the Browns and the NAACP. But when you study the history of this country, you learn that the North was losing until they allowed the Negro to help fight. And when it came to the Browns versus Board of Education, the Supreme Court was actually split, with the decision leaning in favor of the Board of Education and not the Browns and the NAACP. So what happened? What happened was the Chief Justice of the Supreme Court died. The Chief Justice of the Supreme Court was a man named Fred Vinson. Vinson was a Democrat from Kentucky appointed to the Supreme Court by Harry Truman. Chief Justice Vinson believed Plessy versus Ferguson should stand and that states practicing separate but equal doctrine must provide facilities that were truly equal. he would have likely ruled against and turned the court against the Browns. Meanwhile, in another case, Thurgood Marshall had argued that as long as separation existed, the schools would be unequal. After Chief Justice Vinson's death, President Dwight Eisenhower appointed Earl Warren of California as the new Chief Justice. It was Chief Justice Warren that engineered the unanimous court decision that overturned Plessy versus Ferguson and ruled that separate was inherently unequal. And that, ladies and gentlemen, and boys and girls, is how we got the Brown versus Board of Education decision. How many of you learned that in your history books? I didn't. While many argue that today's Supreme Court has become politicized, I'd argue that the Supreme Court has historically proven itself to be swayed by political environments and changing political views. When the Constitution was written, it reflected political and social norms of the time. Two examples of this was the Act prohibiting the importation of slaves, which was Article 1, Section 9, and it stated that Congress should pass no laws prohibiting the importation of slaves for 20 years. The second example is the Fugitive Slave Clause. Article 4, Section 2, Clause 3 stated that no person held to service of labor would be released from bondage in the event that they escaped to a free state. Congress then passed the Fugitive Slave Act that remained law until it was repealed in 1864. These clauses written into the Constitution were politically motivated and subjected to the current societal norms.